Commissioners of the State Insurance Fund, Plaintiff, versus Harry's Nurses Registry Incorporated, Defendant. Judge Milton Tingling, Jr. denied summary judgment, and the Tax 1099 money is supposed to return back to Harry's Nurses Registry, Inc. Plaintiff moves pursuant to CPLR 3212 for summary judgment against defendant in the amount of $122,729.01 plus interest from June 19, 2007 at the rate of 9% per year. Collection costs and attorney fees pursuant to State Finance Law Section 18 in the amount $27,000.38 together with costs and disbursements. Plaintiff State Insurance Fund issued and maintained a workers' compensation insurance policy covering defendants' employees commencing February 7, 2006. According to its terms, the policy was to be renewed annually. On its second term, defendant canceled the policy, effective June 19, 2007. Flic premiums due on the policy were calculated based on the remuneration defendant paid to its employees, as adjusted to include ancillary charges. The total payroll would be multiplied by a constant determined by the New York Compensation Insurance Rating Board, an unincorporated association of insurance carriers. At the beginning of each policy term, defendant would be charged an estimated premium. At the end of each term, an audit would be performed to determine defendant's actual payroll, and either a credit or a bill would be issued. The first problem arose when plaintiff based its estimated premium on defendant's representation that it had 11 employees collectively earning $301,280 for the year, but when plaintiff conducted a midterm audit to ascertain the adequacy of the estimated premium, it discovered that despite representations to the contrary, defendant in fact employed numerous independent contractors who were paid an aggregate of $2,457,483 from February 7 to June 30, 2006. After a complex process of audits, recalculations, and document amendments, plaintiff determined that the final balance due under the policy was $122,729.01. Despite plaintiff's demands, defendant paid no part of that balance. In this action, plaintiff seeks to collect the unpaid premiums, together with interest thereon at the rate of 9% from the date of the policy's cancellation, and collection and legal fees in the amount of $27,000.38. In opposition, defendant contends that plaintiff charged such exorbitant rates for its policy despite negotiated rate reductions, that defendant was forced to cancel plaintiff's policy and replace it with a policy issued by AIG for nearly half the price, which took effect on May 25, 2007. Despite the AIG policy, plaintiff would not let defendant cancel its duplicative coverage until nearly a month after the date requested and then imposed an early cancellation penalty. Defendant argues that such penalty cannot be enforced because it is vastly disproportionate to plaintiff's exposure. Defendant seeks a recalculation of the premiums which would exclude the penalty and include defendant's payroll only until May 25, 2010, when defendant switched its coverage to AIG. Plaintiff counters that the early cancellation penalty is not an unconscionable liquidated damages provision, but rather a short-rate premium, a time-honored, customary, or standard clause, which allows an insurer to collect the premiums it would have charged for a short-term contract instead of the presumably lower premiums it actually charged, expecting the contract to be for a longer term. The court finds that plaintiff may charge a short-rate premium for the partial term of the February 7, 2007 to February 6, 2008 contract year so as to make the premiums payable by defendant equivalent to the premiums plaintiff would have charged had the policy been originally issued for the abbreviated term. The applicable clause in the party's policy provides as follows. If you cancel for any reason other than that you are no longer required by law to have insurance, final premium will be more than pro rata. It will be based on the time this policy was in force, and increased by our short rate cancellation table and procedure. Final premium will not be less than the minimum premium. This provision was subsequently amended by plaintiff as follows. If you request cancellation for any other reason other than you are no longer required by law to have insurance, or if your policy is canceled for non-payment of premium, final premium will be more than pro rata. It will be based on the time this policy was in force, and increased by our short rate cancellation table and procedure. Final premium will not be less than the minimum premium. Nonetheless, there are two main issues which preclude the award of summary judgment to plaintiff: the cancellation date of the policy and the collection costs being charged by plaintiff. With respect to the cancellation date, plaintiff argues that it canceled the policy in accordance with its terms. You may cancel this policy if you secure benefits for your employees in another manner that complies with the workers' compensation law. You must mail or deliver written notice to us which specifies the date you propose cancellation to take effect. Notwithstanding the date you specify, cancellation will not take effect until 30 days after the date you mail or deliver notice to us and 10 days after we file notice in the office of the Chair of the Workers' Compensation Board. Section V1. At Plaintiff's Exhibit A, live. And if this court were to find that clause enforceable as plaintiff interprets it, it could not determine the proper date of cancellation as a matter of law, since glaring by its omission from plaintiff's submission is defendant's notice of cancellation to plaintiff. Not only is the actual notice and proof of its transmission not provided to the court, but plaintiff docs not allege either in its complaint or affidavits on what date the notice was provided and on what date plaintiff filed the notice of cancellation with the board. The only document provided, buried in Plaintiff's Exhibit D, is plaintiff's notice dated May 30, 2007, addressed to no one, advising that at defendant's request it has canceled the policy effective June 19, 2007. Basic summary judgment principles have long held that it is the movant's burden to present evidence demonstrating his or her prima facie entitlement to judgment as a matter of law. Even where there is no opposition to a motion for summary judgment, the court is not relieved of its obligation to ensure that the movant has demonstrated his or her entitlement to the relief requested. Plaintiff has not done so. Furthermore, the court is not persuaded by plaintiff's interpretation of the applicable statute, Workers' Compensation Law Section 54, which provides that when cancellation is due to any reason other than non-payment of premiums, such cancellation shall not be effective until at least 30 days after a notice of cancellation of such contract, on a date specified in such notice, shall be filed in the office of the chair and also served on the employer, provided, however, in either case, that if the employer has secured insurance with another insurance carrier which becomes effective prior to the expiration of the time stated in such notice, the cancellation shall be effective as of the date of such other coverage. WCL Section 54, emphasis added. The practice commentary makes it clear that the 30-day wailing period was enacted solely for the benefit of the employer. The provision is intended to protect employers from being subjected to personal and even criminal liability from an unexpected lapse in coverage without being given a proper opportunity to protect themselves by obtaining other coverage. The old policy should then end when the new valid policy and coverage went into effect. There is no need for duplicate coverage. According to Minkowitz, Practice Commentaries, McKinney's Cons Laws of New York, Book 64, Workers' Compensation Law Section 54, if the employer obtains other coverage prior to the end of the 30-day period, the policy is deemed canceled as to the date of the new coverage. In short, the statute requires first a written notice with a definite cancellation date, and the saving clause as to the effect of other insurance applies only to the period after the notice has been given and before the cancellation date fixed therein has been reached. Thus, if defendant gave plaintiff notice of cancellation before May 25, 2007, plaintiff should have canceled the policy as of that date, when defendant's replacement policy became effective. Finally, plaintiff's failure of proof also dooms its motion for summary judgment with respect to collection costs, which plaintiff seeks to recover pursuant to State Finance Law Section 18. Plaintiff's complaint alleges that plaintiff's collection cost in this action is 22% of the principal amount sought, or $27,038, Section 10, at Plaintiff's Exhibit J. No calculation of actual expenditures and costs of collection has been submitted, or indeed performed other than that percentage. This is inconsistent with the statutory requirement. State Fin. L. Section 185 allows plaintiff to assess employers who fail to make payment within 90 days of the first invoice, an additional collection fee charge to cover the cost of processing, handling, and collecting such debt, not to exceed 22% of the outstanding debt. The assessed collection fee charge may not exceed the agency's estimated costs of processing, handling, and collecting such debt. Since plaintiff has not even attempted to estimate its costs, it cannot prove that 22% of the principal does not exceed such estimate. Counsel's glib statement that if plaintiff prevails herein his office alone would be paid more than $27,000, Florio supporting affirmation, Section 30, does not constitute an estimate. In this context, the court notes that it appears to be plaintiff's custom to charge 22% of whatever amount is due, no matter what relation such percentage bears to the actual costs. Another justice of this court has decried such practice by plaintiff and found it precludes summary judgment in plaintiff's favor. This court sees no reason to disagree. Accordingly, plaintiff's motion for summary judgment is denied in its entirety. Upon service of a copy of this order with notice of entry, the clerk of the Trial Support Office shall restore this action to its former place on the trial calendar.